You know, for millions of us, homeowners associations or HOAs are just a part of life. They're supposed to keep things looking nice, keep property values up, but man, they come with a lot of rules. So, what happens when you think your HOA board isn't just bending those rules, but actually breaking them? And what happens when it all blows up into a full blown legal battle? Well, today we're going to find out by diving deep into one of those cases. So here's a question that gets right to the heart of it all. You want to get involved, you want to make a difference, so you decide to run for your HOA board. But then you're told, nope, sorry, you can't. Is that even legal? That's the core question we're looking at today. And to figure this out, we're not just going to talk theories. We are digging into the official legal decision from a real case out of Arizona, where a homeowner took her board to court over this very issue and a few others. We're going to look at what both sides argued, what the evidence showed, and what the judge ultimately decided. All right, so let's get into the specifics. The person who filed the lawsuit is a homeowner named Kristi Hillebrand, and she filed a formal petition against her HOA, the Camelback Garden Farms Homeowners Association, claiming the board was breaking its own rules and even state law. Hillebrand laid out four main complaints. She said the board ran a shady election, that they were holding secret meetings, that they refused to hand over important records, and that they weren't even enforcing their own rules about RV parking. Okay, so right off the bat, one of these complaints gets tossed out before things even really get started. The judge dismissed the whole RV parking issue because, turns out, Hillebrand had already sued the HOA about that before, and they'd already settled it. So, in the court's eyes, that case was closed. That left the three other big issues on the table. Okay, so before we dive into the courtroom drama, we've got to talk about the rulebook. Because when it comes to an HOA dispute, it all comes down to what's in the governing documents and what the state law says. What's actually written down is what really matters. The two big documents you need to know about are the CC&Rs, that's covenants, conditions, and restrictions, and the bylaws. You can basically think of these as the community's constitution. They're legally binding contracts that you agree to when you buy your home, and they are the ultimate source of the HOA's power. Now, this is a really key point, especially in Arizona law. Most of the time, HOA board meetings have to be open for all the members to attend. But there's a big exception called an executive session. This lets the board meet behind closed doors to talk about sensitive stuff, like getting legal advice or talking about a member's private info. And you'll see why this distinction matters in just a minute. And one last legal concept, and this one is huge, the burden of proof. See, it wasn't up to the HOA to prove they were innocent. The responsibility, the burden, was on Kristi Hillebrand to prove they were guilty. She had to convince the judge that her version of events was, well, more likely to be true than not. And that's a pretty high bar. All right, we know the rules of the game. Now let's step inside the courtroom. We're going to break down how Hillebrand made her case and how the HOA fought back on those three remaining complaints. So here's the play-by-play. On the election, Hillebrand's argument was simple. They unfairly stopped her from being a write-in candidate. The HOA's defense? Hey, our rules don't say anything about allowing write-ins. Then there were the meetings. Hillebrand said they were held in secret. The HOA fired back, saying nope, one was a totally legal private session, one was just an email chain, and the other one was properly announced. And finally, the records. Hillebrand wanted ballot envelopes and payment info. The HOA said, we gave you everything the law allows, and members' financial info is confidential. Sorry. So after everyone's had their say and all the evidence is on the table, the administrative law judge has to make the final call. Let's break down exactly what the judge decided, one issue at a time. First up, the big one. The whole reason we're here. Did the HOA actually do something wrong in that election by not letting Kristi Hillebrand run as a write-in candidate? The judge's thinking really came down to this one phrase. The HOA president looked at the state law, which says candidate names have to be on ballots mailed out beforehand, and interpreted that to mean no last-minute write-ins. The judge basically said, look, you could argue about that interpretation, but it wasn't unreasonable. So the verdict on this one? It's a win for the HOA. The judge ruled that because there was no rule in the CC&Rs or bylaws that specifically allowed write-in candidates, the board had the right to say no. Hillebrand just didn't meet that burden of proof. All right, next on the list, those alleged secret meetings. Did the board actually break the state's open meeting law? Remember, Hillebrand and her witnesses said they never got any notice for 3 different meetings. And the law here is super specific and kind of surprising, honestly. The judge pointed to the actual text of the law, which says that just because a member doesn't get the notice, it doesn't make the meeting invalid, as long as the board can prove they followed the correct procedure to send it. So yeah, you guessed it, another point for the HOA. The judge bought their explanations, ruling that the January 9th meeting was a totally legit executive session. As for the others, Hillebrand couldn't prove the board failed to send the notices, only that she didn't get them. And according to the law, that's just not enough. Okay, on to the last issue on the docket. Did the HOA break the law by holding back records Hillebrand asked for, specifically that spreadsheet showing who had paid their dues? The judge's reasoning on this was pretty straightforward, really. First, the HOA's testimony that the spreadsheet didn't even exist anymore was believable. But second, and this is the important part, the judge said that even if it did exist, state law protects the private financial records of individual members. They wouldn't have to turn it over anyway. And that's the final nail in the coffin. Verdict? No violation. The HOA had handed over all the records it was legally supposed to, and the one Hillebrand really wanted was protected by law. So on all three counts, the judge sided with the HOA. So even though the homeowner lost this case on every single point, it's actually packed with some super valuable lessons for any of us who live in an HOA or maybe even serve on a board. So what can we take away from all this? Here are the big lessons. First, and this is huge, the written rules are everything. If it's not in your CC&Rs or bylaws, it's not a rule. What happened in past practice doesn't count. Second, that burden of proof we talked about, it is a high hurdle. You can't just feel like you were wronged. You have to prove it with solid evidence. Third, courts often give the board the benefit of the doubt. As long as their interpretation of a rule is not unreasonable, it's likely to stand up in court. And finally, it all boils down to one thing. Know your rights, but you also have to know the limits set by the law and your own community's documents. And this whole case really leaves us with a big fundamental question, doesn't it? HOA rules, when they're followed to the letter, can create stability and predictability. But that same strictness can feel like it's squeezing out individual freedom. It's this constant tension that every single HOA and homeowner has to deal with. So where do you draw the line between maintaining order and protecting freedom?